Live from the SABC's Auckland Park studios, welcome to this midweek edition of the Watchdog. My name is Vuyo Mvogo, and on the show tonight...
It's not a blow to the president. What will happen now, the legal team will convene and map the way forward and consider the options going forward.
The Constitutional Court dismisses President Cyril Ramaphosa's application for direct access, where he would have had to challenge the Section 89 independent probe that made adverse findings against him in connection to the robbery on his Limpopo farm in 2020. But what does today's ruling actually mean? Well, our panel of legal experts is going to weigh in. The president's failure to appoint an SABC board, meanwhile, creates problems for Parliament as it makes it's difficult for the national legislature's MPs to play their oversight role. As South Africans make it clear that they are in no mood to celebrate Eskom's 100th years birthday, we sit down with a former CEO of the utility. The Watchdog starts now. The presidency says that the ConCourt's dismissal of the president's bid for direct access to challenge the Section 89 independent probe into Phala Phala is not a blow to the president. Following the ruling on Wednesday, the presidency states that the head of state will still consider whatever options he has available. The president launched a review of the independent probe that was led by former Chief Justice Sandile Ngcobo, which found that President Ramaphosa may have a prima facie case to answer on the theft of money at his Phala Phala farm in 2020. SABC News reporter Kenny Mapanga has that story.
The presidency states that the president has options following the Apex Court's dismissal for direct access to challenge the Section 89 independent probe that made adverse findings against him in connection to the robbery on his Limpopo farm in 2020.
That judgment is what I will call, deals with what I will call a procedural matter with respect to the president seeking direct access to the Constitutional Court. That judgment does not pronounce on the merits of the case. So you are now going into the actual substance of the matter. That judgment just says there is no case for the ConCourt to be petitioned directly. And I think we should put that into context and understand it. I've heard some of your colleagues saying it's a blow to the president. It's not a blow to the president. What will happen now, the legal team will convene and map the way forward and consider the options going forward.
The Apex Court concluded that no case had been made for exclusive jurisdiction or direct access. The main application and the intervention application were subsequently dismissed. However, the order did not delve into the merits of the president's case. ATM's Vuyo Zungula, however, argues that this order means that the Phala Phala independent panel report still stands.
Therefore, what that effectively means is that there is no legal grounding for Mr. Ramaphosa to say that report is legally flawed. That report still stands, and that report still says that there's a serious case to answer. And up until that case has been answered, we as the ATM, including all South Africans, they must not rest.
Meanwhile, the EFF has also welcomed the Constitutional Court ruling and is further demanding that the Speaker of Parliament, as a matter of urgency, puts in place mechanisms and resources for Parliament to investigate the Phala Phala saga. Parliament did not adopt the report. However, investigations into the matter by the Hawks and the Public Protector are yet to conclude. Kani Mapanga, SABC News, Johannesburg.
Well, to help us make sense of this development, I'm joined in studio by Ntabiseng Dubazana from Dubazana Attorneys. And on the line, we have Mudidima Manya, a legal analyst. Good evening to both of you, and thanks very much for your time.
Thank you for having us.
So, Ntabiseng, well, for what the president's spokesperson says, nothing to worry about, you know. Doesn't mean anything. He has a whole lot of other avenues that he can possibly explore. This one means nothing. It's just a question of direct access and nothing more, nothing less.
Well, trying to get direct access was to get the apex court to rule on it, therefore barring all these other avenues that are available to them. They ought to have started with all these other avenues, working their way up to the apex court, wherein if in the high court it is ruled against them, it will go on, so on and so forth, appeal all the way to the constitutional court. So them being denied direct access means that whatever they were trying to achieve by getting the constitutional court to rule on that matter with immediate effect, and therefore granting them whatever they asked in their papers, therefore it means that any other court cannot pronounce on it. So now they have to go back to the drawing board and say, clearly we misunderstood or misjudged the content that we had, that the court, the ConCourt would allow us to present our case and say that, yeah, no, you have a point and you can present your case before us, and therefore we will give you a ruling. So the court is saying, yeah, well, you have some case, but not a case enough for us to give you an ear. Go back to the beginning and then perhaps work your way up. That is basically the gist of what happened.
For you, Mr. Manya? Mr. Manya, can you hear me?
Yes, I didn't hear the question.
Okay, my question was, do you agree with Ntabiseng on, at least on this one?
There's a break in the transmission there. I didn't hear what.
Okay, the spokesman for the president says there's nothing to worry about here. All it was about access to the Constitutional Court. So the president does have other avenues to explore. So it doesn't really affect the case at all.
Well, maybe I didn't get the whole question, but let me explain this part of direct access and exclusive jurisdiction. And as Ntabiseng says, there's a hierarchy of courts, and there are procedures for approaching each of the courts. The lowest in the high courts is the High Court, which is the court of first instance. So there are those 9 high courts in all the 9 provinces. So you actually have to start there. Direct access means you want the Constitutional Court to be the court of first instance, which is actually not permissible except in exceptional circumstances or in matters where constitutionally it's prescribed that the Constitutional Court has to be engaged. For instance, if a high court were to declare an act of parliament to be unconstitutional, it will require the confirmation of the Constitutional Court. So in that instance, you will move directly from the High Court to the Constitutional Court, or in certain instances which involve the conduct or acts of the president as head of state. Now, that's basically what the issues are. So the Constitutional Court, it says, in this particular set of circumstances, firstly, we don't have exclusive jurisdiction. So all the hierarchy must be followed, as Ntabiseng said. But secondly, it says you didn't satisfy us that, 1, there's a constitutional matter that must engage us, and 2, that it is in the interest of justice. So basically, the president is right. It's back to the drawing board. Go and file papers in the High Court, follow the hierarchy, and then we'll meet you, if the matter reaches the Constitutional Court, as the highest court of appeal.
What usually motivates people, Ntabiseng, to go straight to the Constitutional Court? And we're not for a second trying to second guess or anything, but usually, I mean, when people approach lawyers and then whether it's them asking their lawyers to do that or lawyers advising the client that this is what you should do, under what circumstances do people make that consideration?
It, like Ndate Manya just said, it is under circumstances where the ConCourt has exclusive right to be the court of first instance, and they have to pronounce specifically on constitutional matters. But that is also a matter wherein they need to weigh in whether it's in the interest of justice for them to do so. So, for example, in the rights in the Bill of Rights, those things, if they're affected so adversely, you can then make an approach or an application to the court to have direct access in that instance, wherein they can hear your matter urgently, in quotes, instead of having to go through the hierarchy of courts in order for the High Court to confirm and say, yes, indeed, you do have a case where in this part of the rights is incorrect, and therefore we give the Constitutional Court, the right to know, or rather, we have to seek permission from the Constitutional Court to confirm that what we have said here in the High Court indeed is correct. And then the ConCourt looks at the ruling from the High Court, weighs what was weighed upon there, and then says, yes, no, we agree with you. This is correct. We now make it an order of court that we have to change this part in order for it to fit within the Constitution and within the Bill of Rights. So, but then that really, the court has to really have, you as the applicant have to have a very strong case to convince the court that you do deserve for the Constitutional Court to be the court of first instance, because all other courts do have a right to hear constitutional matters and pronounce on them, but it can only be made final by the apex court, having looked at the judgment and what the matter was really about.
But we also know, I mean, from past experience, Mr. Manya, that the ConCourt in particular has been loath to, deal with matters that are supposed to have been dealt with elsewhere. Also because there have been, situations over the past, close to 15 years or so, where they have had to take the job of other people, so to speak.
I'm battling to hear you, but when you speak to Ntabiseng, I hear you very well. So maybe if you turn around, I will hear the question better.
Okay. I'm not going to look at you. I'm saying, Mr. Manya, that from past experience, we also know that the Constitutional Court has been very much aware, but also loath to actually take on cases that they are not supposed to take.
I have lost sound, Vuyo. I didn't hear anything.
Okay. Do you want to take on that one, Tabiseng?
That is very true.
Yeah.
The Constitutional Court really does not want to be the court of first instance. For example, let us take a matter that happened in recent years with regard to the former President Dete Zuma, wherein the contempt of court issue, the matter was taken directly to the apex court, which became the court of first instance, which then pronounced on his rights of freedom in terms of whether or not he should be jailed for his contempt of court, which for most of us in the profession was, it was a bit of a shocker, because if for a contempt of court, you usually don't even get more than 90 days. So now going to the extent of 15 months was quite a shocker, and the court itself can't rescind its own judgment unless you bring compelling arguments, etc., etc. But whereas had it started from the hierarchy and worked its way up, had it been that 15 months in the lower court, it would have gone on appeal, case law would have been cited, etc. All those things, Section 35 of the Constitution, all of those things would have been looked at and perhaps wouldn't have dealt with the situation that we dealt with at that time. So you're correct in saying the court really loads the idea to be the court of first instance. Okay,
we're going to take a quick break. Hopefully, we'll be able to re-establish that line to Mr. Manya. This conversation continues right after this. Welcome back. We're still unable to re-establish that line to Mr. Manya, but we're going to continue with Ntabiseng here in studio. So, assuming Ntabiseng that the president does indeed want to pursue what he couldn't get, from the Constitutional Court, he'll still get from the High Court, and he does indeed want to pursue that. What's going to be his next step now?
I think the wise thing to do would be to start at the beginning, go to the High Court, have the matter sit down for review, and then see whether or not he will get what he wants out of that ruling on that day. But in the event that he doesn't get what he was aiming for, then he still has the second route after that to take it on appeal, which will then go to the SCA. And if at the SCA as well, he doesn't get the answer that he was expecting, it will eventually end up in the apex court for them to hear it, and then they can pronounce and see from the beginning to the end whether or not the decision that was made was correct, balance it against the interest of justice, and then make a decision, a pronouncement on that. Hopefully it will be in his favor. If it's not, then that's where the road basically ends.
But then there are people who say, moot point. Because, I mean, Parliament, yes, enlisted the services of the former Chief Justice together with his fellow panelists. They came up with a report that said the president does indeed have a case to answer. This report was tabled before Parliament, members of Parliament, another arm of the state, voted the way they voted. And so there's really no reason to even pursue this thing.
I think that's why it's important for us to remember the separation of powers, the three legs of our government, which is the legislature, the judiciary, and the executive. So even though the executive has pronounced on this, there's still a review, or rather a report that says that he has a case to answer to. And being the number one citizen of the country and the interest of justice, it is very prudent for him to answer to that in one form or another, either by having it reviewed and then eventually get set aside, or actually answering to the questions that were highlighted in that report, saying, all right, we've looked at all of the evidence, and based on our opinion, 1, 2, 3, 4 needs to be addressed, so we can understand why there was a delay in the report, why weren't the criminal procedure rules followed in order for this to be reported to the right forums in order for it to end up in criminal court, etc., etc. If those things get answered, great. If they don't, then we need to understand why. So I think the element of public interest and the interest of justice, which will then fall within the leg of the legislature and judiciary area, they would probably most likely make it more, in the eyes of the public for there to be an answer in one form or another.
But Dima, what I was asking Tabi saying now, I don't know if you got both my question and her answer, was whether in fact the president, or there's a need for him to still pursue this, because some people reckon that there's absolutely no need. It's a moot point now because Parliament, yes, did set up, this inquiry that was led by the former Chief Justice, and it looked at what was there. It found that the president had a case to answer, and then Parliament voted on their findings, and then decided, that it's okay. This is it for us.
Yes, Vuyo, a reminder that we are a constitutional democracy, and we have got various organs playing specific roles. The purpose of the Section 89 process was to enable the National Assembly to make a determination whether the serious misconduct worthy of the impeachment of the president. Now, procedurally, it would start with a complaint. It would start with the appointment of that committee. It will go to the report of the committee being tabled in the National Assembly. It would require the National Assembly to take a decision through a vote. Now, if the National Assembly has already decided that it's not pursuing the matter further, nobody can enforce that report except the National Assembly. And I think one needs to caution that it was actually a decision of the National Assembly, not even a decision of the Speaker, and the Speaker can't overrule the decision of the National Assembly. If anybody is unhappy with the decision of the National Assembly, the correct procedure is to take the National Assembly on review. My own sense is that even if the court were to find something untoward with the National Assembly, I am not sure whether the court can order each member of the National Assembly to vote in the manner that the court deems fit. Those people will still vote the way they want to vote. And I think it's another reminder that we have a party political system. So if the political parties decide that we're going to vote for impeachment, and they say to their members, you vote for impeachment, the other party says, well, abstain. The other party say, vote for against the impeachment. That's what will happen. That's the type of discourse which will take place in the National Assembly. That does not mean, however, that other processes like the investigation by the Hawks, the public protector cannot continue. But the report was meant for impeachment purposes, and that process has effectively been aborted.
What if, and of course this is hypothetical, and Ntabiseng spoke about some of those things. What if a court of law says exactly what you just said, that we can't force the National Assembly or members of the National Assembly to vote, either way for that matter. However, we found this flaw about the process. That perhaps it wasn't given sufficient time for certain processes to be followed, which would then perhaps speak to the integrity of the very same report. Given also the things that people raised subsequently when a lot of people spoke about how evidence was not led and so on and so forth, and how that was problematic. What if a court says, notwithstanding the fact that we cannot force you to take a decision either way, there's a problem here, another problem here, or something, or this could have been addressed, or this could have been explored. What if?
Yes, I think the court will have to make, and I think this is the principle, that the court must make orders which have practical effect. So effectively, the Constitution says the body which must take the decision to impeach is the National Assembly. It's not the court. Yes, the court may find that, well, to this extent, maybe the report is valid or is invalid. But the actual procedure is that the discourse must take place in the National Assembly. And the question is, can the court, and the discourse in the National Assembly is by way of vote. Let's assume the court were to say, go for a secret ballot. And 70% of members of the National Assembly vote against proceeding with an impeachment. What else can the court do? Can the court order each individual member of the National Assembly to vote for an impeachment? You see, that's the conundrum that we will have. And I think it's important to understand that we use a party political system. That is our constitutional structure. And it might be unpleasant, it might be inconvenient for other people, but, and let me just divert. And you saw what happened in Tshwane yesterday, and you saw that two political parties are saying, we want to find our members who didn't vote in terms of our party position. That is the reality of our constitutional politics.
What if I'm saying, of course, it's okay, as Mr. Manya says, we can't force you. Party political system, decisions are taken the way they're supposed to be taken. However, saying, this is what we also found, right? That procedurally, there may have been a problem here or there. And then say, it's up to you to decide to then take it back to whatever committee or structure of Parliament to see if perhaps there isn't, the court won't instruct them to do that, yes, but it becomes apparent, or it would, logic and common sense would dictate a review, and then Parliament then, in a way, gets or has to consider a possible review of whatever kind. It may well end up where we are right now with the same, or like going back to voting again, and then the same outcome. But does that possibility not exist?
It does exist, but I think also we need, even though we are a politically driven constitution, the element of separation of powers now comes fully in play in this situation, because the judiciary cannot stretch its arm way beyond outside of its boundaries to instruct what the executive should do. So by virtue of saying that, yes, when we look at what the review procedures, what happened in the report, how it led up to where it is, we find that we are in agreement with what was decided in the report. However, we cannot, unfortunately, instruct what the executive should do in this instance. What we can then say is perhaps the executive can look at restarting the process. Let's see if this can be another voting situation. And like Ntate Manye said, perhaps it's done in a secret ballot, etc. But we cannot restart the process of the investigation.
Or an ATM or UDM or whatever MP can say, oh, on the back of what the court has just said, there's a good enough reason for us to take this further. Maybe elsewhere.
Correct.
Even outside of Parliament, for that matter.
Correct. So now, like Ntate Manye said, when it happens that way and says that one party says, okay, the court says we have a little bit of a leg to stand on, and now because we are part of the executive who do have the powers to actually take this matter further, let us now take this court ruling and say this report should be put in place and then take it further, or saying that no, we actually want it to be reviewed or left alone. Now they, as the political parties, are having a say in what should be done in this situation, which therefore absolves the court of saying that we instructed the executive to do something, and our separation of powers exists and it's clear. Yeah.
And of course, as you're saying earlier, Mudidima, we still have your SIUs and your Hawks investigating, the matter as well. We don't know what's going to come out of their own investigations. But one thing it's telling us is that this matter is not dead yet. Far from it, actually.
Yes, it's probably got a way to go. As I said, one of the options is for those who are dissatisfied with the decision of the National Assembly to take that decision on review. And obviously, the basis would be whether the voting was correct and not necessarily what discretion each member exercised, because the court will never substitute your discretion. It will simply, it may say to you, I don't think you should have done it this way, but the court is not going to say to you, you should do it this way. Then, of course, you have the police who must investigate. You have the SIU or the public protector. And as I say, at the end of the day, each of those organs have got their own procedures. Now, the police may take the report and look at what would be relevant to their investigation, but the report was not meant for a police investigation. The police have got their own procedures. For them to put together a docket and take it to the National Prosecuting Authority, they have to follow their own standard procedures. The same with the public protector. She may take note of this report and look at it and say maybe this aspect can be followed up. So we probably still a long way to go. But I must say, until the National Assembly decision is taken on review and set aside, that is a political process. The impeachment is a political process. To that extent, the report is dead. In fact, it may as well be that the president is challenging this matter, not because he fears the criminal process or the SIU or the public protector, but probably for his own personal reputation. But I don't necessarily think it still has any legal effect in the National Assembly. The National Assembly has decided it's not taking the matter further.
And that's what I'm going to leave. Let me thank both of you for agreeing to come on with the Dima Manyan Tausing. Thank you very much for both of you for coming through. Now, to this now, the president's failure to adopt an SABC board, meanwhile, has created problems for Parliament. The National Legislature's Public Finance Watchdog body, that's the Standing Committee on Public Accounts, or SCOPA, today could not play its oversight role. It follows a bombshell dropped by SABC CEO Madoda Mxakwe before the committee this morning, that he did not accept the delegated authority to be the SABC's accounting authority. Mxakwe said he had some reservations about assuming the role of accounting authority, a role normally played by the board.
SABC executives were once again sent packing by SCOPA because there's no accounting authority at the public broadcaster. It's now 4 months since the expiry of the term of office of the previous board. The public broadcaster's chief executive officer explained why he did not take up the role.
It says, taking note of the temporary nature of this appointment, you are advised not to enter into any new or major financial commitment. The problem with that, Chair, is that all our business plans in terms of operations, sales, and various aspects of the organization are by nature commercial, and it means that there would therefore need to be some financial commitment to be made.
The Department of Communication and Digital Technologies, which represents government as the SABC's shareholder, told Scopa that it was not aware that Mxakwe did not accept the delegation of authority.
It was a big embarrassment that I come here this morning under the impression that the designation has been made of the accounting authority, and there is an accounting authority, only to learn this morning when we are here.
Scopa blames the department for the leadership vacuum at the SABC. The committee says while there are delays in appointing the board by the president, the shareholder should have made sure that there is continuity by ensuring that the necessary appointment is done.
The biggest indictment is that at an operational level, you can't seem to get your house in order whilst those other processes are playing out, however long-winded they might be, and as incorrect as it might be, ultimately landing them in court.
The committee has described these developments as reckless and irresponsible, as well as waste of taxpayers' money. It says someone must be held accountable and foot the bill for the expenses incurred. Lula Mamatya, SABC News, Parliament.
To this now, Eskom was established on this day 100 years ago. As the power utility marks its centenary, measures to deal with its current crisis are in sharp focus. Established with the intention to provide cheap electricity and to power up growing industries, today the struggling power utility is begging consumers to use less of power. To reflect on the state of the country's power supply, I'm joined by Eskom's former chief executive, and that's Mr. Jacob Marocha. Good evening, sir. Thanks very much for your time.
Good evening for you.
Well, 100 years, and I mean, things were different back 100 years ago. For starters, I'm not being an apologist for apartheid, but they created it to, do a lot of things for themselves. They cared less. I mean, in the township where I grew up, I mean, when I was born in the part of the township where there was electricity, but there were other parts of the townships and the new townships that were developed after that had no electricity. So that was the reality of black people in South Africa, even though there was this state-of-the-art, well-established utility that was supposedly taking care of the country's needs.
Yes, that's our history. But I think what we should ponder about is that, you see, Eskom, like many other utilities which were established around about that time, the early 1910s, the early 1920s, were established as a base to industrialize, and on the back of huge findings of gold, of platinum, coal, and all sorts of minerals that we're beginning to find in South Africa. So 100 years on, it helped establish an industrial base of South Africa. And South Africa, from an industry perspective, is no different from some of the industrialized countries. Yes, of course, it was meant for a section of the population, but here we are.
Fast forward to 1994. Of course, there were these huge disparities. You still had to sustain and grow, these industries, but we also had to power up these vast, areas, of our country. I'm talking about the rural areas, but also, the townships that were also sprawling at the time, because with the democracy dividend, you simply had to do that, go where Eskom hadn't gone before. But what kind of entity did the new democratic government inherit in 1994? And realistically, well, back then, what could it still do? That which the older Eskom had never done.
Well, the 1994 Eskom had excess capacity, was self-funding, but it also had more intentions to electrify, and electricity for all became the slogan. We went into a huge electrification drive. The orders of magnitude was that in 1994 the electrification was around 30% of the country, because it particularly was looking after one section of the population. But as we speak now, we're closer to the 90% electrified. I remember at the height of electrification, we're doing close to 300,000 connections per annum. And that is, I think, from a RDP commitment, it was a huge commitment. The village where I grew up didn't have electricity when I grew up until I went to varsity, but it's only after 1994 that that area was electrified. So I think there's a legacy there of actually bringing electricity to most people. And I think electricity is very powerful in terms of its transformative nature. Small businesses, studies, general life becomes different with electricity. So there was that, and of course, as in 2001, the global energy company of the year globally, its rating in terms of credit rating, it's in some cases actually better than government. So there were highlights even post 1994 in terms of the performance of Eskom and its contribution to society. Yes.
So we inherited a utility that had the ability, the capacity, the finances, everything it needed, but also the reputation, if it needed to raise money for argument's sake, to actually do what it promised to do after 1994.
Yes, absolutely.
And where did the wheels come off?
Well, the wheels have come off indeed. I think there's issues of policy issues, internal issues over the past few years, and we thought this time around from 2018, 2019 there will be a turnaround, but we're still struggling. But I think it's an important institution, and energy, as a platform for everything is important. So for me, the focus is going to be how do we turn it around? In fact, we have got no choice but to turn it around because there isn't anything else. People talk about other forms of energy. They are important. They're going to make a huge contribution. But for now, what we should do absolutely is to turn around the energy utility.
I'm going to get to a couple of specifics on what you said, but allow me to take a step. I'll take just one step back. You mentioned policy. What were the policy challenges that made it, or that that brought us, or that may have been responsible, even in part, to bring us where we are today? And I'm saying this at the back of my mind. Something else, I remember reading the late Kada Asmal's book, about where he talks about cabinet meetings and what often happened there. But basically talking about people who didn't play their part, or didn't take their jobs perhaps as seriously as they ought to have. From a policy perspective, were there flaws in how we approached policies that may have played a part in bringing Eskom to its knees, basically?
Well, I'm very circumspect to always go back as if those policy flaws were not rectified. I mean, there was a policy to say we want to bring in new capital, Eskom we shouldn't build. So there was some delay in beginning the build. But that policy, from a perspective of whether it was well thought through, was it a good policy? I think so. I think everywhere in the world where you had a vertical monopoly, state-owned, the idea was break it up, bring in new capital, bring competition so that there can be efficiency improvements. So that was based on that. Yes, it didn't happen as it was supposed to, but it was rectified. In the end, the government says, go ahead and build. We give you the space to build. But there were other things that needed to happen. For instance, the funding needed to happen. It didn't happen. So there was a funding gap that also currently still contribute to Eskom. But the decision to build was made, Kusile, Midupi, Angola, where it started. But subsequently, they became late, so operational issues.
And they became very expensive.
Very, very expensive. Now, come to today, I think the biggest issue now is that what we have as an installed fleet is not performing to the standard that is expected. And there are current issues that needs to be dealt with. There's some historic issues, but for me, a lot has to do with what we have installed. Can we make it perform to standard so that we don't have this gap, which sometimes goes to as far as 8,000 megawatt of gap in terms of supply and demand?
Can we?
We should. You see,
but can we?
No. The question, you see, sometimes it's no longer a matter of we should or we shouldn't. The question is, we have to because we've got no options, right? The question is.
Okay, let me tell you why I'm asking whether we can. In other words, I'm asking you to answer the very same question you posed. Because a couple of times, and in the very recent past, you heard the finance minister saying, and he said this in an interview I did with him last year, and he said it again, I think it was in the Eastern Cape, I was listening to him talking about Eskom's problems. He said, we spent a lot of time trying to fix Eskom instead of bringing electricity to the grid. Now, I don't know from what place that particular argument, but he keeps on making this point. And for me, it again, sorry to take you back, bring me to the policy. What does this man believe? You know, that which will make the difference between, or be the difference between enabling Eskom to do what you're saying it must do, whether we like it or not, you know, and not doing it.
Yeah, the point is the following. We've got about 50,000 megawatt installed in Eskom, but we get about 26,000, you know, almost like half of what we should get. Now, any other option to build similar anew is not going to bring you close to what you have. Whatever it takes to fix what we have, for me, is the most credible path to recovery. Because what are the options? Now, you know, let's just talk options. What we need is we need dispatchable baseload. Renewable energy, just because of its nature, will not replace coal. All over the world, it doesn't. All over the world, they build more renewable on top of what you have. In the long term, once you have enough renewable and also other what is called dispatchable low carbon sources, then you can begin to reduce on your fossil. But for now, the world is building up the renewable on top of what they have. So we should do the same. We should build as much renewable.
It's not replacing.
It's not replacing.
Yeah.
So what is broken, or what is not actually broken, is what is not operating. There is some that is broken, but there is some that is working but not working, you know, working intermittently. So we need to make it much more, to operate much more consistently. And for me, that's the quickest to solve the problem. Then let's talk about what options do we have. And I think we're beginning to hear, I mean, in the minister's budget vote, we begin to hear options of concessioning some of the power plants, meaning you bring in other people who might have capital, might have skills to complement what Eskom has. So there are options. The question is, What is the budget for those options? How long they're going to take? What is the implication? But for me, the issue of let's abandon Eskom for something else. What is that something else? We don't have it.
Okay. That's a couple of quick ones. Let's start with what to do with Eskom and what it will take for it to give us the best that it can give us. What needs to be done there?
You must fix the coal power plant. I mean, the issue is deep maintenance fix so that we can get consistent. And part of it is, of course, is capital and skills, but part of it, there are 40,000 people who've been running these things within Eskom. And those people, in my view, I think have been minimized, almost like you incompetent, you corrupt, you not connected to the cause of the country. They must actually be re-energized because those are the people we have. So for me, in broad terms, re-energize the people of Eskom, bring in capital, bring in skills, and any other thing, but focus on rebuilding the career.
Now, our economic challenges. An economy that's not growing, would be being told that Eskom is just making things worse. So where's that money going to come from? Or what have other jurisdictions that we know of done to then make up for whatever the fiscus cannot?
Let me look at the IPP
absorb.
program. Let's look at the IPP program. What are we doing? We're auctioning capacity, private capital bring in their money. What we give them a long-term contract, and we don't actually have to expend the money.
Yeah.
So you could do the similar model where you attract capital into the current power station, they inject the capital, but they get remunerated on a long term with either a concession, a power purchase agreement, or whatever. So there are models to bring in new capital in an industry where people can actually put in their money, but they are remunerated over time. So those are the models. And South Africa, you must understand, the energy system is a proxy for your economic system. So if you've got faith in the economic system, you have to fix the energy system with the view that you're going to be remunerated as the economy picks up. We still have the mining industry. We still have large world-class deposit in South Africa that the world needs. So there is a case for people to actually put in their money into the energy system so that the economy and the industry can work.
But as far as you know, do these models, you say, exist across the world? Are they part of the conversations that are currently taking place about what to do with Eskom now?
Exactly. I mean, I'm saying in the budget vote, as a condition for dealing with the loan of Eskom, the minister says, consider concessioning some of the power stations. So concessioning meaning you actually almost like rent them out to other players to fix and actually get paid over time.
Sorry, I'm probably going to be a little flippant here.
Right, okay.
But he's the minister. He's in the executive. His boss is the president. And he's sitting around there with all his other colleagues who are responsible for energy and all these other portfolios. When he's calling or asking people to consider, who is he asking?
Well, in fact, let me.
He's saying, this is what we're going to do tomorrow.
Maybe I used the wrong, because I think they're saying as a condition for us dealing with the Eskom debt, part of it, what we are expecting, these are the things that we're expecting from you as Eskom. So I think it's instructing in a way. So I agree with you.
That's how it's coming through.
Yeah.
But anyway, let's just then say, let's talk about these other things in a couple of minutes that I have, if I still have. We've had big announcements before. And I'm again taking you back to some of the things you've just raised. That private industrial players like your mining companies, your Sasols, can generate up to like 100 megawatts, But over the past year, it's been frustration after frustration. That program hasn't really gone very far, if anywhere at all. It's been stuck there where there have been all these conversations, yes, in the presidency with people who are trying to unlock, these things and so on. But there hasn't been a great deal of movement. And we're told, and I remember speaking to Andre de Ruyter saying, isn't this going to be a threat to Eskom's existence? And that's perhaps why there's been a bit of reluctance to even consider this option. But it was considered and approved. President announced at the end of the day, but it has hardly, started.
Well, from where I'm seeing a lot of activity in the private sector to do what is called self-generation, embedded generation. Yes, there's been some red tape, but the people in the presidency removing that. What I'm hearing, there's close to 9,000 megawatts that people have committed to over the next period.
But there was self-generation, but there was also how you also assist or boost the grid. In other words, so that you can be able to then generate more to give to, to sell to Eskom.
Yeah.
So that you strengthen the,
Yeah. You see, self-generation helps in a way that
those people will be off the grid.
They are not off the grid. Part of the consumption will be self-generated. Therefore, it releases capacity to the grid so that overall there's less demand, then you can have less load shedding. That's the theory.
Yeah.
But that part is not going to be a big solution to the big elephant in the room, which is the performance of the current fleet. And in my view, 95% of the effort should go there. The other things are going to complement. The other, IPPs, self-generation are going to complement. But what we need to do and focus on is fix Eskom.
Mr. Moroka, we're unfortunately run out of time. Thank you very much for your time. Really appreciate it.
My pleasure.
Former Eskom Chief Executive, Mr. Jacob Moroka. I honestly wish we had more time, but unfortunately we don't have, and that's how we come to the end of tonight's show. To join us again tomorrow evening for another conversation about South Africa. For now, though, it's a good night from the Watchdog team.